Okay, what I want to talk to you about today is probation violations. And I'm going to talk to you like I would talk to a friend because I want this to be accessible and understandable. And so, first I'm going to cover the basics of probation so that if you know all the basic stuff already, you can skip ahead to this point so that you can see kind of more of the nitty-gritty. But so for probations, you got felonies and misdemeanors, but you've also got straight probation and deferred adjudication. Those are the two kinds of probations you can be on. The difference is with a straight probation, you get a conviction up front and you have a defined term of custody that you are sentenced to, but that sentence is probated for a period of years, and that is your probationary period. So say for instance you're on a third-degree felony. The range of punishment is 2 to 10 years. The prosecutor agrees to do a 2-year prison sentence probated for 5 years. And so basically you get the minimum prison sentence, but you don't even get that because you get probation. And you only do the prison sentence if you mess up your probation. Otherwise your case gets discharged at the end and you're fine. So 2 years is your max. It's capped. That's the worst you can get once you accept that probation. But you get a conviction, right? So the other kind is deferred adjudication. Deferred adjudication is a type of probation where at the end of your probation, once you've completed all your conditions, satisfied them, and the period has expired, your case gets dismissed. So you're never found guilty up front. And if you successfully complete it, you're never found guilty. The only problem with deferred adjudication, not the only problem, but one of the big problems with deferred adjudication is if you do mess up and they make a motion to proceed to adjudication and you're then found guilty, the judge has the whole range of punishment open to sentence you. So rather than having it like the straight probation we talked about, having it capped at 2 years, where that's the most you can get, if it's the same third-degree felony, you can get up to 10 years. The judge has that all open for them to sentence you based on your probation violation. And probation violations aren't judged at the same standard that an original criminal case is. You know, for an original criminal case, the state would have to prove your guilt beyond a reasonable doubt. And that's a high burden. That's a hard thing to do. Whereas in a probation violation, they just have to prove that you did something that violated your probation or failed to do something that constituted a probation violation by a preponderance of the evidence, which means they have to show that it's more likely than not that you did what you're accused of doing or failed to do what you're accused of failing to do. That's not as hard. So that's the basics, the very basics of probation violations. Another very basic thing is that when it comes to putting out a warrant for a probation violation, whether it's for a deferred or a straight probation, a warrant is issued for violation. The prosecutor files a motion to revoke your probation or to proceed to adjudication. The same thing, but for different types of probation. Basically, they're wanting to cut short your probation and sentence you. And a warrant gets issued, and then you have to deal with that warrant one way or another. And for a straight probation, you are not entitled to a bond. Now, on felonies and misdemeanors, they treat this a little differently. But on felonies, you're not going to get a bond on a straight probation unless the judge grants it. And the judge doesn't have to. On a deferred adjudication, the law says that you're entitled to a bond. So the judge has to set a bond. And now the question is, how much will the bond be? Whether it'll be something that's still high enough that it's effectively out of reach for you. So you may have bonds that are still too high for you to make, and you are stuck in jail even though you're entitled to a bond. You've got a bond, you just can't make the bond. So, all right, now let's get into the nitty-gritty, the details of this. So what happens on a probation violation? What do they do? So a probation violation can occur for numerous reasons. You can violate your conditions in a lot of different ways. They have a whole list of things. When you get your probation, you get a list of things that you're supposed to do. They check the boxes and they number the boxes, and so you know what your terms and conditions are and what things you have to finish off before you're done. It could be fines, court costs, it can be restitution sometimes. You have to take courses a lot of times. You have to get clean your analysis. You have to stay out of trouble, don't get any new cases. You have to report monthly, community service hours. There's a lot of things, sometimes treatment. A lot of things you will have to do to complete your probation successfully, and if you don't do them, they can make a motion to violate your probation. Motion to proceed to adjudication, a motion to revoke your probation. And that's when you run the risk of getting sentenced. Now, you may feel that you've done something bad enough that you're definitely going to get sentenced, and they're probably going to hit you with the max. It's easy to prejudge your situation and think, oh no, I've stepped in it now, there's no way out. But I want to caution you not to do that, because there's a lot of forgiveness in the system. There's a lot of tools that they can use to try to get people back in line when they've messed up. And I can tell you, every way that you can mess up, other people have done before you. And a lot of those other people have gotten some grace, gotten some mercy, and gotten back on probation and allowed to at least try to finish it out. Now, not all of them do. If you mess up once, you're likely to mess up again. And there's only so much leeway they'll give you before they say, you know what, we're done with you, we're going to send you to prison. So keep that in mind. But also know that there's hope. There's oftentimes something that can be done. And, the more experience you have from your lawyer with dealing with these things and kind of being creative about ways that this situation can be addressed, having the right approach with probation and prosecutors, and being careful on your case, and looking at all the details and seeing what makes a difference, and what in that list of things they put in their motion, what's important and what's not. There's usually one or two things that they care about, and the other things are just things they list because they haven't been completed yet. That's just how they do it. So not all that stuff is always going to be important. Now, sometimes they'll just list the two things that they really think are important, and everything else, especially towards the end of a probation when you've done most of your conditions, well, there won't be much to list anyway. So a couple things. Find someone who knows this stuff and who can really help you. Find someone who's creative, someone who doesn't judge you, because you got enough of that coming your way. You don't need your lawyer to judge you. You need your lawyer to understand you, to take an interest in your case, to see you as a human being with goals and drives and ambitions and things about your life that are good, that are worth saving. And when that person, when your lawyer understands you, they can communicate that to someone who has to make a decision on your case. I always like to say, in any case, when there's a situation like this, there's people on the other side that are trying to do their job to the best of their ability. And if we're going to get them to make a decision in your favor on a probation case, we've got to give them a good reason, not just fluff. It's got to be real. So I talk about reasons versus excuses. Excuses don't get you very far, but reasons can make all the difference. If you have a reason why something happened, and you can tell me about that, and I can tell them about it in a way that persuades them, that can make all the difference to getting you either back on your probation or sometimes even discharged altogether. If your probation has already expired, discharge is more likely. There's different kinds of discharges. There's all sorts of options, and we just have to find one that fits your situation and returns you back to your life as quickly as possible with the minimum of stress and pain and suffering and expense. And that's what we do. So, hope that helps. I'm going to go visit a couple people in jail now.